Good afternoon, and welcome to the National Family Support Technical Assistance Center's webinar, Substance Use Disorder and Mental Health Privacy Rights for Individuals and Families. I am Gail Cormier, the Director of NFSTAC, the Family Center of Excellence. We are led by the National Federation of Families, and I want to thank you all for joining us today. Before we get started on our presentation today, I would like to go over a few housekeeping items. Today's webinar is being recorded. The recording, along with the PowerPoint presentation slides and any additional resources, will be sent via email within 3 to 5 days to all who registered. All attendees will be muted for the duration of today's webinar. However, we still look forward to hearing your questions, and we're happy to help you with any technical issues. To ask a question or request TA, please send a message in the chat box. Just click on the chat button on the dashboard at the bottom of the Zoom window. The icon looks like a speech bubble with 3 dots. When you've opened the chat box, type in your chat and press enter. We will be watching the chat during the entire presentation. We ask that you take time to complete a short feedback survey using the link provided at the end of the presentation. This survey will help us continuously improve our webinars, and it also fulfills our SAMHSA funding obligations to provide them with important data required by our contract. Please note, all information will be confidential and we will respect your privacy. Please also know that we do not offer CEU credits for our webinars, but we will send you a certificate of attendance within 3 to 5 days after the presentation. I would like to thank SAMHSA for allowing us to share this information with you today. And again, thank you for joining us. Now, I would like to tell you a little bit about our co-presenter, Diane Oten. Diana Oten holds a law degree and is Executive Director of the SPAN Parent Advocacy Network, a family-serving, parent-led organization located in Newark, New Jersey, which has housed New Jersey's federally designated Family-to-Family Health Information Center for 16 years and the state's Parent Training Information Center for over 33 years. Diana and her husband have raised 4 adult children from diverse backgrounds and have a 14-year-old granddaughter. As a parent, Diana founded her town's first special education parent advisory council and also served as the co-chair of the Mount Clair Council of PTAs. Welcome, Diana. I'm so excited to hear what you're going to say. Next slide. So our objectives today will be to identify how federal health privacy laws protect substance use disorder and mental health treatment information, especially when the family is involved in care. Understanding how individuals and families can work together in ways that supports recovery and respects the individual's privacy and choices. And most importantly, recognizes key points for families to consider when sharing or requesting SUD or mental health treatment information. So let's start off with the poll. Please rate your level of agreement with the following statement. I don't always know what questions to ask providers to ensure that my family can be involved in my care, or so that I can be involved in my family members' care. So do we A, strongly agree, B, agree, C, somewhat agree, or D, disagree? Oh, look at the results. Somewhat agree. I know that I would somewhat agree too, because sometimes I personally am a little confused on what I can and cannot ask about my adult children. Let's go to the next slide. So confidentiality overview for individuals and families. Here's the anchoring concept. This is how individuals and their families can work together in ways that are helpful toward the individual's recovery. So we're going to give you some skills to actually help you to talk to providers when it is right to do. Why confidentiality? Privacy is the key to recovery. Everyone should be able to get the help they need without worrying about who knows it. Family members, you have a role to play in helping your loved ones get better. But the privacy is the law, and know the facts about individuals' privacy rights and accessing confidential care. There are ways we can be helpful within the boundaries of the law that we will discuss today that will help families and caregivers support their loved ones. So this is going to be really an interesting conversation. Which laws apply? Well, we have Health Insurance Portability and Accountability Act, that's HIPAA, the SUD privacy laws, state privacy laws, and also providers also have an ethical duty of confidentiality and additional professional licensing requirements. Please note, today's discussion will focus on privacy protections under HIPAA. This is where we'll be focusing. If you or your loved one receives SUD treatment services from a Part 2 program, additional privacy protections will apply. And I'm going to send it over to Diana.
Thanks so much, Gail. And before I start, I just want to thank both the National Federation of Families and the Center of Excellence for the wonderful resource that they have developed that I've already shared with my staff, and also let people know that I have experienced this issue both as a daughter and as a mother. So just briefly, HIPAA protects the privacy of a broad range of general information that's related to health in any form that can identify an individual and that relates to past, current, or future physical or mental health conditions or healthcare services. This can include, name, contact information, diagnosis, treatment, clinical notes, prescriptions, etc. So HIPAA has a very broad range in terms of the kinds of health information that it protects. So today we're going to talk about sharing information with family. And today we're using the word family broadly to mean anyone that the individual chooses to involve in their caregiving. And family can include, but isn't limited to, adult children, parents, siblings, partners, and even friends. So if you are the parent of a son or daughter who's affected by a mental health condition or a substance use disorder, you want to be informed so that you can help your son or daughter and keep them safe. But as children develop from childhood through adolescence and into adulthood, both your rights and their rights about health information change. HIPAA tries to balance protecting privacy, assuring safety, respecting professional judgment, and including family, friends, and caregivers in treatment or in care coordination as appropriate to the circumstances. Our presentation today primarily focuses on adults, adult sons, daughters, adult children. That is on individuals who are 18 or older. That's because in most cases, parents are their minor child's personal representative and can exercise all of their minor child's HIPAA rights, including the right to access their complete medical record and to authorize or direct the disclosure of their health information to third parties of their choosing. However, it's important to know that a healthcare provider can ask a parent to show proof of their status as a healthcare decision maker for their child. There are also some important exceptions that may prevent a parent from being their child's personal representative or from accessing their medical records, including, for example, if their child independently consented to a healthcare service, no other consent is required for that service to be delivered, and the person who has been receiving the service or consented to the service has not requested that their parent be treated as their personal representative. The state, territory, or jurisdiction allows minors to obtain a healthcare service without the consent of a parent, guardian, or other person who's acting in loco parentis, and that child, a court, or another authorized person has consented to the treatment, or the parent voluntarily agrees that their child's information would be kept confidential from the parent. Hipaa generally follows state law about parents' authority over their minor child's treatment. So where state law gives the minor child the ability to consent to their own treatment, and the child has consented to that treatment, Hipaa does not give parents the right to access information about that treatment. Some of the areas where state law may do this are in regard to mental health treatment, substance use disorder treatment, and also treatment regarding pregnancy or other reproductive health care. So parents and individuals need to know the law in their own state, territory, or jurisdiction on things such as the age of majority at which an individual is considered an adult. That's usually 18 years old. Another example might be if someone is emancipated, either through court action or if they are married or have joined the military. If a child, even a child who's not an adult, is considered to be making their own decisions, or if the right to make decisions for the child has been removed from the parents, these are situations where the state law would not allow parents to access the information. So please, even though we're going to be talking a lot about Hipaa, which is a federal law, a law that applies across the United States, please be sure to find out more information about what your state or territory or jurisdictional laws are regarding access to health records. Some states have laws that either require or permit or even prohibit healthcare providers from giving parents access to certain health information, even about their minor child. Once a young person attains the age of majority in your jurisdiction, they are considered adults and capable of exercising all of the health privacy rights under Hipaa, unless they lack decision-making authority. So in our presentation today, we are going to discuss where and when and what healthcare providers can release or discuss with parents when their child has reached the age of majority. So when does Hipaa permit a healthcare provider to share information with family? So the first area that we're going to talk about today is individual consent. Because Hipaa protects the privacy of a broad range of general health information in any form that can identify an individual and relates to past, current, or future physical or mental health conditions or the provision of healthcare services, it's important to know the types of protected information that might be included here. So names, contact information, social security numbers, addresses, email addresses, phone numbers, fingerprints, diagnoses, clinical notes, lab results, and prescription histories, among other types of information. But it's also important to note that Hipaa doesn't apply to everyone. It applies to what is known as covered entities and their business associates. So covered entities include almost all healthcare providers, health plans and insurers, and healthcare clearinghouses. Business associates include entities or individuals who aren't members of the covered entity, but who receive, maintain, generate, or transmit protected health information on behalf of the covered entity. And so we're going to start here with this slide with individual consent. So Hipaa permits a provider to share any health information as authorized by the individual with their written consent or to somebody who is a personal representative under state law. So Hipaa always allows the disclosure of health information to people when an individual authorizes by written consent their provider to share that health information. And again, that can be families or friends or anybody that they want to share the information with. As noted earlier, if a parent is their adult child's personal representative under state law, HIPAA also permits the disclosure of health information to that parent. There are many ways that personal representative status may be established: through a written directive, a medical power of attorney, a court appointment of a guardian or conservator, a determination of incompetency, or other recognition consistent with the law in that jurisdiction that would permit a parent to act on their adult child's behalf in making healthcare decisions. However, the ability to access healthcare information may depend on the specific authority that is granted to the personal representative by law. For example, if the personal representative is authorized by law to make all healthcare decisions, then generally they can have access by law to the individual's healthcare information broadly. But if the personal representative's authority is limited to a certain type of treatment, then access to the healthcare information will be limited to only that information related to that type of treatment. So it's very important for individuals who are really concerned about the release of their healthcare information to ask the provider for a release of information that authorized disclosures to preferred family members, and make sure to keep a copy, and also be sure to give a copy to anybody that you want to be able to access your information. So now let's go to the next category, and that is when an individual does not object. So a provider can disclose protected health information to a family member or others involved in the individual's care when the patient is present during the disclosure, the discussion, they have the opportunity to object, and they don't object to the disclosure. Also, a provider can share information if, using their professional judgment, they determine that the individual does not object. So let's explore what this looks like through a case study. So here's our first case study. Leo is admitted to the hospital for an opioid overdose. While his sister Emma is visiting him in the hospital, the doctor enters the room to discuss Leo's recovery and treatment options. And Leo asks Emma to take notes for him. And I do want to respond to one comment that was made in the chat about an adult child not being a child, being a son or a daughter. I'm 67 years old, and I'm still my mother's child. One of the, we often would use son or daughter in the past as opposed to adult child, but the reality today is that there are individuals who do not call themselves son or daughter because they would prefer a gender neutral term. And so that is why we have not used the term son or daughter a lot throughout this presentation, and instead are using adult child. And perhaps it's time to develop a new term. So if somebody has a gender neutral term, then we would love it if they would share it. So a non-binary individual, for example. So what can the doctor share in front of Emma, who is Leo's sister? Here are our options. Nothing. Emma must leave the room because she is not Leo's parent or child. Nothing. Emma must leave the room because Leo did not sign a consent form authorizing the disclosure. Anything about Leo's recovery and treatment options because Leo had an opportunity to object. Or anything from Leo's health history, including information protected by stricter health privacy laws for substance use disorder treatment records and HIV information. So this should be a poll. Let's see what people think is the answer. Nothing, because she's not Leo's parent or child. Nothing, because Leo didn't sign a consent form. Anything about the treatment and recovery options because Leo had an opportunity to object. Or anything from Leo's health history, including information protected by stricter health privacy laws for substance use disorder treatment records and HIV information. What do you think? So great. So the majority of people said that anything about Leo's recovery and treatment options because Leo had an opportunity to object. So let's go to the next slide. The answer is C, anything about Leo's recovery and treatment options because Leo had an opportunity to object when the doctor asked to discuss recovery and treatment options. Emma's exact relationship to Leo doesn't even matter. Emma could even be a close friend. And no written consent or authorization is required for disclosure. Because Leo was there when the doctor was sharing information, in fact, Leo asked Emma to take notes for him, Leo had the opportunity to object and did not, and therefore anything can be shared about his recovery and treatment options. Now, a practice tip for individuals is to begin a conversation by clarifying what the doctor plans to discuss, or even by asking for a few minutes alone with the doctor before having the conversation. Because even if Leo has the opportunity to object, some parts of the conversation may go into areas that Leo may not have been aware would be discussed in the conversation. So just to make sure that he is clear about what information will be discussed with his sister and the information he's asked her to take notes on, have that conversation and make sure you know that Leo knows what the doctor is planning to say or talk about, and or to do that before Emma comes into the room, or right when Emma's there before the conversation is taking place. So let's go to the next slide. So the third area that we're going to discuss is when the individual is not available. So let's go to the next slide. Hipaa permits the provider to share information with family involved in the individual's care if the individual is not present, and I'm going to put that in quotes, or lacks capacity, and the provider determines that doing so is in the individual's best interest. And here we give some examples when an individual lacks capacity because they're unconscious, sedated, severely intoxicated, having a mental health crisis in some cases. If an adult, please go back to the previous slide. We're still going to be talking about this slide, the slide on individuals not available. Please go back to the previous slide. I'm not sure why we're not moving to the next slide, but pretend we're on the previous slide that's still talking about when the individual is not available. So if an individual is disoriented or delirious or unaware of their surroundings due to, for example, opioid overdose or a mental health crisis, and arrives at an emergency room for treatment, the doctors, nurses, and social workers may notify their parent of their location and general condition. First, the staff has to determine if that individual agrees to share the information or if the parent is their personal representative. But if the individual is not able to make decisions because, for example, they're unconscious or sedated, severely intoxicated, or disoriented, then the doctors, nurses, and social workers may contact the parents without the individual's permission when they determine that doing so is in that person's best interests. However, the health professionals can only share the information that is needed for notification, such as the individual's location and general condition, or that is directly related to the parent's involvement in their care. In addition, if they're incapacitated or are unavailable to give consent because of some emergency situation, Hipaa allows health and mental health providers to make decisions about sharing medical information with family, friends, and caregivers based on the professional's judgment about what is best for the patient, factoring in their prior wishes if known. So, for example, if a patient who is addicted to opioid misses important medical appointments without any explanation, a primary health provider at a general practice may believe that there is an emergency related to the opioid addiction and under the circumstances may use their professional judgment to determine that it is in the individual's best interest to reach out to the emergency contacts, such as parents or family members, and inform them of the situation. So it can be helpful to establish yourself, if you're a parent, before your adult son or daughter or adult child has a crisis situation, to let those providers know about your status as their helper or caregiver involved in their care, and also who to call about their care. In cases involving significant impairment to the individual's functioning, parents may actually need to gain legal recognition, for example, by obtaining a medical power of attorney to establish their status as the personal representative under Hipaa. Remember that in these circumstances, the provider may only share information related to the emergency and not information unrelated to the emergency. And when the individual regains the capacity to make their own healthcare decisions, the provider must offer them the opportunity to object or agree before any additional information is shared. It's also important to note that state laws or professional ethics requirements may impose stricter limitations on sharing protected health information. So now we're going to just mention the fourth area that's addressed on this slide, which is the threat of serious harm. So now you can go to the next slide. So Hipaa permits a provider to share information with anyone in order to prevent or lessen the threat of serious harm to the individual or anyone else. Anytime there is a threat of serious and imminent harm to an individual's health or safety, or to others, including their parents or family members, Hipaa allows their health and mental health providers to share information with those individuals if they reasonably believe that they are in a position to prevent or lessen the threat. The individual's age or legal relationship to the parents or other family members is not a barrier when such a threat to health and safety exists. For example, if an individual threatens to commit suicide by cutting and their parent is in a position to remove knives and sharp objects from the home, the provider may notify the parent to enlist their assistance with removing dangerous objects and to discuss a plan for potentially obtaining a higher level of care for him or her. One note here, when a provider is authorized to share an individual's health information under Hipaa, any of the circumstances that we've just discussed, that information can be shared face-to-face, over the phone, or in writing. So if the individual is not, if the individual is struggling with any of these issues, it may be useful again in advance of an emergency to help them identify friends or other caregivers whom they would like to be notified in the event of hospitalization or emergency, and to encourage or assist them to give the names of the individuals to their healthcare providers. I will let you know when it's time to advance the slides. So we're now on this slide. Hipaa may permit a healthcare provider not to share information with a personal representative if they have concerns that doing so would put the individual's safety or health at risk. For example, if a provider has a reasonable belief that a parent may have abused or neglected the individual, or a provider has determined in their professional judgment that it's not in the individual's best interest, they cannot disclose information and they will not have to treat the person as the individual's personal representative. Next slide. So that's a brief overview of the circumstances under which Hipaa authorizes people, such as parents, to be provided with protected healthcare information, including, for example, if they are their individual's personal representative, or if there's a situation that involves potential serious harm to the individual or to others. So now let's look at a couple of case studies and have some discussions. So let's go to the next slide and let's talk a little bit about Sylvia. So Juan takes his daughter Sylvia to St. Elmo's Treatment Center for inpatient mental health treatment. Juan is Sylvia's primary caregiver and shares information about Sylvia's medical background, medication, and providers. A few days later, St. Elmo's calls Juan and says Sylvia is ready for discharge. But they don't provide any further information about Sylvia's current status, medication changes, or recommendations for follow-up appointments. So let's go to the next slide and let's have a poll about what St. Elmo's can share in front of Juan, Sylvia's father. So here are your choices. Nothing. Juan must pick up his daughter and figure out the next steps on his own because he's not Sylvia's legal guardian. Nothing. Juan must pick up his daughter and figure out the next steps on his own because Sylvia didn't sign a consent form authoring the disclosure. Anything about Sylvia's recovery and treatment options because Juan is her primary caregiver. Or D, we need more information to answer this question. So what do you think the answer is? So thank you for responding, and the serious, significant majority of you gave the right answer, which is that we need more information to answer this question. So let's go to the next slide. We're going to talk about what Juan needs to know about Hipaa and how Juan can work with St. Emil's to better coordinate sharing information about his daughter's mental health treatment. Before we really know about what Juan needs to know about Hipaa, there are some missing pieces in the puzzle, as most of you realized. First, we don't know how old Sylvia is. Is she still a minor? In which case, Juan would most likely be deemed Sylvia's personal representative as her father. We also don't know about the privacy laws of the state or territory in which they live. Does this state allow or require or prohibit healthcare providers from giving parents access to mental health information about their minor children? If Sylvia is an adult, has she consented to St. Elmo's sharing information with her father? Or does Juan have documentation that Sylvia has already designated him as her personal representative in writing? Or is there a threat of serious imminent harm to her or to others, in which case Hipaa would allow providers to share information with Juan if he's in a position to prevent or lessen the threat? So again, the answer to this scenario is we need more information. But how can Juan work with St. Elmo's to better coordinate sharing information about his daughter's mental health treatment? First, Juan can have a discussion with appropriate staff at St. Elmo's, sharing information about his status, either as Sylvia's personal representative due to his status as her father, if she is a minor child, or any documentation that he has confirming that he is her personal representative, even if she is an adult. He can also share important information that he has about what has happened in the past when she went home from previous inpatient mental health stays, including, for example, whether she exhibited behavior that was a danger to herself and or to others. Remember, Hipaa also does not prohibit healthcare providers from listening to parent concerns, experiences, and information about their adult child status. He can also ask that St. Elmo speak with his daughter prior to him picking her up to get her consent for St. Elmo's to share information with him. And he can ask that an appropriate healthcare provider be with Sylvia when he comes to get her so that he can ask questions about her treatment and things he can do to support her once she is home, in the hopes that she will not object when the conversation occurs. Moving forward, if Sylvia is stabilized when she is home, Juan can discuss with her the importance of her identifying him as her personal representative in case of future situations, and ask her to agree that he be notified in the event of hospitalization or an emergency, and to provide his name and contact information, as well as the documentation of his status, to her healthcare providers. If she won't designate Juan, Juan can also discuss with his daughter the possibility of another trusted adult serving in that capacity, like another relative or a close family friend who could fulfill that role in the future. Next slide. Let's talk about Lola. Lola is 19 years old and in her first year at college, and she's admitted to inpatient psychiatric care at Green Valley. Lola's parents visit her traveling from out of state. Green Valley tells them that Lola does not want to see them and has not consented to sharing any information with them. Green Valley won't let Lola's parents share any information about previous treatments, medications, etc. And Lola's parents are upset because they are financially supporting her and she's still on their health insurance plan. Next slide. So what can Lola's parents do about the situation? Nothing, because Lola is an adult and has the right to refuse to see her parents or disclose any information to them. They can speak with the staff and share information with them from their perspective, but they can't see her or discuss her treatment without her consent. Or they can demand to see Lola and discuss her treatment because they financially support her and their insurance is paying for the facility. So please answer the poll. So what are our answers? So the majority say they can speak with the staff and share information, and a substantial minority say nothing because she's an adult and has the right to refuse to see her parents or disclose any information. Let's go to the next slide and have a discussion, a talk about this. So what do Lola's parents need to know about Hipaa, and how can they work with Green Valley to support her treatment and recovery? In this scenario, we know that Lola is an adult, so they can't demand to see her or that the staff discuss her treatment just because they financially support her or even because their insurance is paying for the facility. They need to know that as an adult, Lola has the right to decide who has access to her healthcare information. However, they also need to know that just because the providers can't share information with them doesn't mean that they can't share information with the providers about their past experiences or parent concerns. So the answer to this scenario is B. They can speak with the staff, they can share information that they have from their perspective, but they can't see her or discuss her treatment without her consent. So how can they work with Green Valley to support Lola's treatment and recovery? In addition to sharing information that they have about past experiences, including barriers to recovery, as well as their perspectives on what has or hasn't worked in the past, including medications and treatment options, they can request that the staff let Lola know that they're there, that they love her and want to see her and support her, that they will only talk with her about the things she wants to talk about and will leave whenever she doesn't want to talk to them anymore. That still may not change Lola's mind, in which case they will not be able to see her or talk with her, but they can ask the providers to have that conversation with Lola. Again, moving forward, when Lola is no longer in the psychiatric facility, her parents can have a conversation with her about letting them be more involved in her care, including being able to speak with her healthcare providers and letting providers share information with them about her treatment and recovery. So let's go to the next slide. We'll go to case study number 4 with Zander. So Zander, who is 24 years old, is admitted to the emergency department unconscious due to a drug overdose. And an exam reveals that Zander is pregnant. Their father, Bill, arrives at the hospital and asks for information about Zander's status. A nurse tells Bill that Zander is being treated for a drug overdose and that further examination revealed that Zander is pregnant. Zander is upset once Zander is no longer unconscious. Zander is upset to learn that the hospital shared this information with their father. So let's go to the poll for this scenario and ask about Zander's options. So the first option is Zander has no options. The nurse had the right to tell Zander's father about the situation because Zander took illegal drugs. B is nothing. The nurse had the right to tell Zander's father about the situation because Zander's drug use was harming their unborn child. And C, file a complaint because the nurse released confidential information without their consent. So what do people think Zander's options are in this situation? The majority of you said C, and that's correct. Let's go to the next slide. So we're going to talk a little bit about whether it matters if Zander were a minor, and also what Zander and Bill need to know about HIPAA. Both Zander and Bill need to know that while HIPAA protects Zander's confidentiality rights, in situations involving an individual who is incapacitated or unavailable to give consent due to an emergency situation, HIPAA does allow health and mental health providers to make decisions about sharing medical information with family, friends, and caregivers based on the provider's professional judgment about what is best for the individual, factoring in their prior expressed wishes, if any. In this case, we don't have any information about Zander's prior expressed wishes. Zander was incapacitated and unavailable to give or withhold consent because of the emergency situation. Zander was brought to the emergency room for treatment in an unconscious state, so the doctors, nurses, and social workers could notify Bill of Zander's location and general condition if they felt it was in Zander's best interests. So they could share the information that was needed for notification of a location and general condition. The issue is not whether Zander took illegal drugs. If Zander took illegal drugs, but their capacity to make decisions about the release of health information was not impaired, then sharing any information would need Zander's consent. On the other hand, the nurse sharing information about Zander's pregnancy likely goes beyond the information that they should have shared because it's not directly related to the overdose that led to the emergency room treatment. And if Zander regains the capacity to make healthcare decisions, the hospital must offer Zander the opportunity to agree or object before any additional information is shared. So in this case, Zander could potentially file a complaint about their HIPAA rights being violated with the Office for Civil Rights within 180 days of their discovery of the alleged HIPAA violation. There may also be state-related confidentiality laws that apply in this situation, and if so, Zander could also potentially file a complaint under state law. So would it matter if Zander were a minor? It could well matter if Zander were a minor. Remember that in most cases, a parent is considered their minor child's personal representative, and providers don't need to get the minor child's permission to release health-related information to their parents. This would likely include both information about the overdose and about the pregnancy. So this is another time when it's important to know about the state or territory's laws about release of protected health information, because the state or territory may have additional rules regarding release, especially when it concerns mental health, substance use, and/or reproductive health information. So in this case that we were talking about Zander, the information about the overdose, which caused the unconsciousness, is information that could likely be shared with the parent. On the other hand, the information about the pregnancy likely goes beyond the information that can be shared with the parent. Let's go to the next slide. And we'll have our final case study. And this is about Frank. And I don't know about any of you that are on the webinar. This is a situation that our family organization frequently is faced with. A situation of an individual who has a dual diagnosis of both mental health challenges and developmental disabilities. So Frank is 18. He's reached the age of majority in his state. He has a dual diagnosis of mental health and developmental disabilities. He's still in high school with an IEP, an individualized education program, and he's living at home with his parents. Due to isolation and the lack of services due to COVID, he's been having frequent outbursts. hitting his mother, and engaging in self-injurious behavior. So in a session with his behaviorist, Frank threatens to run away and kill himself. When the behaviorist speaks with him about wanting to discuss his care with his parents, he becomes enraged and shouts, "No, no," over and over. So let's go to the poll. What can Frank's parents discuss with the behaviorist? So nothing. Frank is verbally refusing to have the behaviorist speak with his parents. Anything about Frank's care because he lives with them and they pay for it. Anything about Frank's care because he has a cognitive disability. Or information about his threats to run away and kill himself because the provider believes it's necessary to prevent a risk of serious harm to Frank. So what do you think about this situation of Frank? Excellent. Information about his threats to run away and kill himself. Let's go to the next slide. Thank you. So what do Frank's parents need to know about Hipaa? In this situation, Frank is an adult. And just because he has a cognitive disability does not mean that he no longer has rights to control the release of his protected health information. Further, just because he lives with his parents and they financially support him, doesn't give his parents the right to access his protected health information if he does not agree to have it shared with them. In this situation, Frank is clearly letting the behaviorist know that he does not wish the behaviorist to discuss his case or his care with his parents. On the other hand, Frank's parents also should be aware that the behaviorist can share certain information with them, including information about Frank's threats to run away and kill himself, if the behaviorist believes that there is a threat of serious and imminent harm to the health and safety of Frank or to others, and that Frank's parents are in a position to prevent or lessen the threat. For example, in this case, the behaviorist could discuss with the parents a plan perhaps for obtaining a higher level of care for Frank, removing objects that Frank could use to kill himself, making it more difficult for Frank to run away, etc. But that doesn't mean that the behaviorist can discuss everything about Frank's treatment with the parents, just the information about his threats to run away and kill himself because the provider believes it's necessary to prevent a risk of serious harm to Frank. If Frank were a minor, it would matter because, again, a parent is considered usually to be their minor child's representative, regardless of their minor child's cognitive abilities. In that case, the behaviorist could discuss all of Frank's care with his parents. This would also involve and be the case if Frank's parents had guardianship, a written directive, a medical power of attorney, determination of incompetency, or other recognition consistent with state law, territorial law, or jurisdictional law that would permit a parent to be their adult child's personal representative. The specifics of the authority granted to the parent are important. For example, some states have limited guardianship options that give the guardian the authority to only make certain decisions, such as financial decisions. In that case, the personal representative's authority would be limited to the information relevant to financial decisions. And I do want to make another point. While in this situation, Frank's parents may consider guardianship, the act of obtaining guardianship may have broader implications that parents don't understand. For example, in some states, obtaining guardianship over the adult child may lead to that person's loss of all civil rights, such as the right to vote. We encourage family organizations, provider agencies, and individuals to access the information and resources from the National Resource Center for Supported Decision-Making about alternatives to guardianship that could still allow parents to be involved in their adult child's care. And you can just go to supporteddecisionmaking.org. Another reason that parents may really want to think about alternatives to guardianship is that when you obtain guardianship, you are involving the legal system in decisions about your adult child's life. And I want to mention, I was doing a workshop on alternatives to guardianship, and a young adult with mental health challenges who was working as a peer supporter stood up and supported me when I said that guardianship can have many implications that parents may not want to have happen. Go to the next slide again. We're still on the slide about, yeah, thank you. So that person stood up and said that when he was 18, the school encouraged, before he turned 18, the school encouraged his parents to get guardianship over him. And that's actually the majority of situations. It's schools that are telling parents to get guardianship. And so they got the guardianship. And a few years later, when they no longer believed that their adult son needed to have that kind of intensive support or decision-making by them, and they tried to get the guardianship eliminated, the court refused to take away the guardianship, even though the parents and the adult son both agreed that it was no longer in the adult son's best interest. And the court has the right to make that decision. And in that situation, the court could have ordered somebody else to be that adult child's, that adult son's guardian. So there are many, many implications. The supported decision-making, National Resource Center for Supported Decision-Making has great trainings and resources, examples, tools, etc. So how can Frank's parents work with the behaviorists to support Frank's treatment? Again, even if Frank is an adult, his parents can share information with the behaviorist from their own personal experience with Frank, including the information about the isolation and lack of services due to COVID, his frequent outbursts, the fact that he's been hitting his mother, and also engaging in self-injurious behavior. This information would be helpful to the provider in determining, for example, how serious Frank's threats are to kill himself, and whether or not he poses a serious and imminent threat, not only to himself, but also to others, such as parents. The services that Frank is supposed to be receiving in his IEP and that have been interrupted due to COVID would also be useful information for the behaviorist to understand. And so we do have just one thing, Paula asks, how do I prevent the hospital from sharing my information across hospital departments, i.e. OBGYN, dental therapists, etc. So the providers can only share the information to other providers that you give consent to, or if, for example, if you threaten the OBGYN in a conversation with your psychiatrist, and the psychiatrist believes there is a serious and imminent threat to harm of the psychiatrist, they can certainly share that information. That's one reason why it's really important to look at any kind of information that a healthcare provider, the forms that a healthcare provider may be asking you to share with others, give them permission to share with others, and make sure that it doesn't authorize the release of information to other providers, even if they're at the same hospital or in the same network. So let's go to the next slide and we'll kind of reiterate some of the key points and talk about proactive planning. So the key points that we've talked about is, first, make sure that the individual is asked their preferred role for their family. Communication by the individual and the family, if they're allowed to do so, early and often, so it's not an emergency situation before these questions come up. Remember that family members can always share information with providers to promote the individual's care and treatment. There are times when family and caregivers are allowed by law to receive information about their loved one's care and circumstances. And providers have some discretion about when to share and when not to share with family based on their professional judgment. So I'm going to say a few more points before we go to the next slide. in addition to these key points, it's always a good idea for a family and an individual who has substance use disorders or mental health challenges to plan proactively together. Talk together about authorizing parents to serve as the personal representative regarding healthcare, if that's something that the individual wants to do. If the individual doesn't want to designate their parents in that role, it's important to have a discussion in advance of an emergency about identifying other trusted adults, such as family, friends, or relatives, who the individual would like to be notified in the event of a hospitalization or emergency. And also, the contact information for those individuals, and make sure for those, people that the individual does want to designate, and then encourage the individual to give those names and contact information to the healthcare provider, again, in advance of the emergency. Individuals may not be aware that the healthcare professionals can't give information about their status or treatment plan, et cetera, in many circumstances without their consent. So individuals and family members having a conversation about this and discussing why it might be important to have the parents or another responsible adult be available to support them by having access to health information is critical. Also, it's important for individuals and families to understand that many healthcare providers will require individuals to sign a written authorization, sometimes called a Hipaa release or release of information form, before disclosing protected health information about adults. Hipaa authorization is a detailed document signed by an individual that gives providers permission to use health information for specified purposes or to disclose protected health information to a third party who's specified by the individual. So individuals and their parents should discuss, even before the individual becomes an adult, and certainly as they transition into adulthood, about how privacy rights change under Hipaa when an individual reaches the age of majority, and why it might be important for parents to be able to discuss and get access to health information with the healthcare provider even after the individual becomes an adult. Generally, a Hipaa authorization will include the name of the person who's authorized to make the disclosure, the name of the people that are authorized to receive the information, a description of the information that's allowed to be disclosed, the purpose or purposes for the disclosure, an expiration date or event, such as the individual's discharge from a hospital or psychiatric facility, and then the signature of the individual or the person who is authorized to make healthcare decisions on behalf of that individual. An authorization remains valid until its expiration date or unless it's revoked in writing by the individual. Hipaa doesn't impose specific time limits or authorizations, but more restrictive state laws may control how long a Hipaa authorization remains in effect. So at this time, I'm going to open it up for questions and ask Michelle to pose some questions. And also note that there's a lot of great information in the fact sheet or infographic that is co-branded by the Federation's TA Center, as well as the Center of Excellence on Protected Health Information, which not only has great information in a Q&A format, but also links to more detailed information from SAMHSA and also from the Office for Civil Rights that goes into more detail about all of these issues. And I found it, even with having some information about Hipaa before in my previous lives and in my current status, I found it to be a really helpful tool that I shared with all of my staff and our parent leaders and volunteers. So let's open up for some questions, Michelle.
Hey, Diana, we've got some questions from folks about how they can find those specific laws that you mentioned, that each state seems to have a different set of laws that govern age of majority and what they need to disclose information. I know personally, I found that to be true from facility to facility when I was trying to get information. Can you recommend a site that folks could go to in order to be able to find out what those are?
There on the different websites that have information about what HIPAA requires or prohibits, some of those websites do specifically have links to state laws governing confidentiality of protected health records and disclosure. And we can certainly send out a link that people can access. I do want to say that I would also speak to the state agency that governs both child and adolescent behavioral health and adult behavioral health to find out the laws that they believe govern the situation, because while there may be one law about general health protected information, many states also have additional information in their laws about certain types of protected health information, like mental health information, substance use disorder information, reproductive freedom information. And so I would not just rely on that generic state law, but would also want to find out about state laws that, or territory laws or jurisdictional laws. DC isn't a state, but they are a jurisdiction that has their own laws, to make sure that there wasn't some additional information or additional exceptions that, that are required in certain situations.
Diana, does that also apply to releases of information? We talked about having a release of information. Would folks need a separate release of information specifically maybe designed for mental health versus the release of information they may have for their child for their physical health care? Or is there one that will work for both? Or is that also
generally those forms, those releases don't just say HIPAA. And they don't say, you know, just the information that HIPAA, you know, allows. And so they're usually pretty generic, and they say any health information. And so in that situation, that release would work for anybody. And I also want to mention that, you know, tribal governments also have jurisdictions. They are also a jurisdiction, and certainly people should be very, very aware of what the tribal laws are and rules are. And thanks, Cheryl, for reminding us that that tribes are also have, you know, the status as jurisdictions, and may also have rules that govern the release of protected health information.
And we also had a question about minors. You talked about the age of majority being different from state to state. Does a child being pregnant or married affect them as a minor? Does that affect a parent's ability if the child is a minor? And
that's also something that's based on state law. So some states want to encourage minors to seek reproductive health treatment, substance use disorder treatment, and mental health treatment. And so those states will allow minors to make their own healthcare decisions about those categories of care, and would not allow providers to release information about those categories of care without the minor's consent.
And going back to the scenario about Frank, would his parents need to have a power of attorney in that scenario you gave, or is that not necessary, or how would that affect and play out?
So remember, there's several ways that HIPAA allows parents to be able to be their adult child's personal representative. It could be a power of attorney. It could be guardianship or conservatorship. It could be other form of written documents that are signed by the adult individual that give permission for the parents to act as the personal representative. And an interesting resource on the supported decision-making website are some examples of tools that parents can use and get their adult to sign to allow them to still be involved, for example, in their education. Anybody here who works with parents who have youth who have an individualized education program, an IEP, know that at the age of majority, the notice, the decision making at that IEP goes to the adult, and the parents no longer have the right to make those decisions. And so, it's important. It's not just important in healthcare, but also for education and in other areas that parents have this discussion. And again, have this discussion before their child becomes an adult. The more that we as parents involve our minor children in our discussions with their providers and our discussions with them about the kinds of things that work or don't work for their care, our concerns, our commitment to support them and not try to take over their lives when they become adults. The more we engage our minor children as they continue, as they transition into that adulthood process, the more likely it is that they are not going to see us as a threat or as somebody that's trying to usurp their authority when they become an adult. So if you can, individuals who are not yet 18 and parents who have individuals who are not yet 18, don't wait till that 18-year-old status when individuals may not feel comfortable in having you continue to be a part of their care decisions.
And I have one more question that's very specific, so I'm going to read it to you to make sure I get it right. Does HIPAA require a court-ordered subpoena or adequate assurances to resolve objections when a local health official requests protected health information for individual investigations for assisted outpatient treatment or involuntary outpatient commitment?
That's, I'm gonna actually pass on that question. I do think that is a question that has a lot of implications for state law. In general, if an individual gives consent for that information to be shared, it can be shared. In general, if an individual denies consent for information to be shared, it can be denied. There may be implications for that denial. For example, if an individual is seeking to be treated in a certain facility, perhaps, or by a government-run facility, that facility may require the release of information to them before agreeing to provide that treatment. In that case, the facility would not provide the information, but the individual would not be able to get the care.
And Diana, that takes us to the end of the questions we've gotten, except I do want to say several people have asked about resources, and we have a list of resources, and I've also been jotting down the resources that people have mentioned and shared with us, and I will add those to the resources that we send out with the slides.
And again, I also want to add that when you look at this document, the Understanding HIPAA, what parents need to know about privacy in their adult child's health information, that was from both the National Family Support TA Center and the Center of Excellence on Protected Health Information. It's a great format, and if you access it online, it has wonderful links to more detailed information about all of the scenarios and types of questions, frequently asked questions that have come up. So I really encourage you not only to look at it, in a hard copy, but also to access it online so you can do that deeper dive into the linked information that you can see in the in that resource when it's online. And at that point, I want to thank all of you for participating, for all of you being so active in the chats, and also for your great questions. And I'm going to turn it back over to Gail.
Well, thank you, Diana. That was fabulous. I really appreciate it. And I hope this was an informative and helpful event. I want to thank Diana again for today and thank everyone for your participation. A special thanks goes to the NFSTAC staff and to PHI staff for helping us run today's event smoothly. Now, we have that request for you. I mentioned at the top of this event, please take the remaining time to fill out our survey. This will help us improve our events and fulfill our SAMHSA obligations. I thank you, everyone, and join our newsletter. The link is right there. So we value your opinion, and we hope you have a wonderful rest of the day. Thank you, and thank you, Diana.